responsible for all the webinars and all the technical things at the center. Thanks a lot, Muna.
Thank you very much, Mona.
Thank you. I'm glad to meet all of you. I'm
Thank you,
learning
Mona.
all of you today. Thank you.
Likewise.
And we have also our interpreter and translator, Arsin Azerbaijan. So welcome, Arsin, with us. And I think, Muna, you can start by explaining, because we have now 71 attendees. I think
We're good to start, yes.
yeah, because I think Professor Brown is also needs to go, right? You need to go at 6:30 sharp. And we are aware of, we will try to manage to finish at 6:30. I promise you that. Okay, so I think, Muna, maybe it's good if you start by explaining how everything is gonna go and how they can use, you know, for the attendees, how they can use the interpretation, and that, you know, maybe you start, then we will start the webinar.
اوكي، اهلا وسهلا بالجميع ونورتونا. اليوم الويبينار في فيتشر انكم انتم تقدروا تسمعوا الترجمه بالعربي. الترجمه بالعربي راح تلاقوها عندكم على البانل بسايد البارتيسيبنتس زي شكل الكره الارضيه، اضغطوا عليها تقدروا تسمعوا كل الويبينار باللغه العربيه. هذا بالنسبه لسماع الويبينار. اذا حابين تسالوا اي اسئله للبانلست خلال الويبينار تقدروا تستخدموا الشات، واحنا عاده ننصح تستخدموا شيء اسمه الكيو اند اي، بتلاقوها كمان جنب الشاتنج مكتوب عليها كيو اند اي. الحلو في الكيو اند اي انها بتوصل للبانلست مباشره، والبانلست بيقدروا يعني نقدر احنا نعمل نتاكد انه كل سؤال من اسئلتكم تم الاجابه عليه. هذا بالنسبه للترجمه وكيف انتم تقدروا تتفاعلوا مع الويبينار. ايش رح تلاحظوا انه بالويبينار ما بتقدروا لا تفتحوا فيديو ولا تفتحوا مايك. في عندنا سيكشن كامل له علاقه بالكويشنز، بتقدروا ترفعوا ايدكم واحتمال نقدر، بعرفش الدكتوره سناء كيف، بس احتمال نقدر ناخذ منكم مداخلات نفتح لكم للترجمه وكيف التفاعل. For the panelists, in case like okay, so the attendees is going to be asking questions mostly in Arabic, and Dr. Sana'a is going to make sure to either translate them. Okay, we're going to either open the mics for the attendees to speak in Arabic. In that case, you could hear the translation. You too, you have a feature in which you could hear in English. So we could do that for you, or Dr. Sana'a could decide just to translate the questions herself. This is up to you, Dr. Sana'a, how you want to manage the whole technicality behind the questions asked from the attendees. I think we're good to go from there. Now we're having 83 attendees. Let's do it.
Okay. First of all, I would like to welcome everyone to النجاح 5th University webinar. This is, you know, like we've been doing various webinars, and this is the third legal one. We are deeply honored to have all of you with us today. So please allow me to pass the university greetings and appreciation for your participation in this webinar that addresses a very important topic on the practical and theoretical level. I will start by giving a brief introduction about why we chose this webinar and why each kind professor will talk about what he's going to talk about. And I have to say, we tried our best to have diversity, and hopefully in the future, we will have more female constitutional lawyers. However, we are very glad to have all distinguished professors with us today. So constitutions and the state of exception. Often conflated, the state of emergency and the state of exception represent two different meanings. When discussing these kind of terms between academics, there is always this kind of contradiction and issues between the terms. The state of emergency refers to a typical constitutional provision that allows the executive branch to govern with emergency powers in times of a crisis. Crisis varies in its definition upon the Constitution, but is often defined in these provisions as a potential threat to national security or public health, such as war, invasion, or even pandemic, etc. In these exceptional circumstances, in order to respond rapidly, governments are able to take actions without complying with statutory duties that it would normally have to comply with. Typically, state of emergency provisions includes strict stipulations regarding time period, a definite time frame. Extensions usually requires approval from Parliament. and often contain compulsory requirements that allow the legislative body an opportunity to review all the measures and arrangements adopted during the emergency period. The set of exceptions that we would like to discuss in this webinar is alternatively a concept used by the philosopher George Agamben, and he's the philosopher that we want to focus on today, to describe states in which the use of exceptional powers as a technique of government has become normalized. Crucially then, the state of exception cannot be said to apply in all authoritarian states. Rather, according to his theory, it must occur within a kind of type of state where there is a political structure that allow a degree of space for political activity. To put it simply, then, a state of exception is not necessarily a state of emergency. Rather, a state of exception may emerge if the state of emergency is used indefinitely, or to use Agamben's words, becomes the norm. Recent work by political scientist Saimon's Mabon, who we are very happy to have here, and I have to say thank you, Saimon's, and Saimon's is my mentor as well, has begun to highlight this process of passing exceptional laws as becoming ordinary practice in many areas of the Middle East. Therefore, almost region-wide process of normalizing emergency powers could be occurring in this area. So Saimon's is going to highlight and talk about this from a theoretical point of view. And again, thank you so much for being with us. And we're going to rely so much on the theory that you're going to present. This said, the way governments in MENA region dealt with the pandemic and the exceptional powers which were used makes us question the actual role the constitutions in this area play, regardless of the restrictions on emergency powers in almost all constitutions. Were constitutions respected? We saw the changes that made in certain constitutions after Arab Spring, such as Tunisia and Egypt, where the president is no longer the only one who declares the state of emergency. But was adding strict provisions enough to stop any abuse of powers during such times? Can the term of paper constitutions still apply to MENA constitutions after Arab Spring? Therefore, it's my absolute pleasure to be sharing this platform with the amazing Naathán Brown, whose books have influenced so many in Palestine and beyond. It is a true honor to have you with us, Professor, and many of the students who are attending this webinar have read your book about Palestine. And I think even in our constitutional awareness campaign, we put your book in the video because it was a true influential book for many scholars here. So thank you for being with us, and we can't wait to listen to the presentation you're going to give about MENA constitution and state of emergency. Moving to another scholar who I deeply appreciate as a dear friend and one of the constitutional lawyers that his work in the MENA region is highly respected and appreciated, Dr. Francisco Bياجي. Francisco has been with us in the first constitutional awareness campaign and on the second one. His work has been translated even without him knowing that we did that, and has been distributed to the students. The criteria that he put about constitution making has been used a lot in many master students, and one of the thesis that is written about the future constitutions in Palestine is mostly relied on his work. So thank you, Francisco, for that. Quoting from his paper that he has recently written after giving the training to the Constitutional Court in Palestine, I will quote from your paper. Modern constitutions often provide for different safeguards against potential abuses committed during a state of emergency, namely procedural safeguards, time safeguards, and substantive safeguards. When analyzing the role played by constitutional courts in reviewing the declaration and extension of the state of emergency, one can notice that in most of all the cases, modern constitutions do not grant any role to these institutions. In some cases, they only grant them a weak role, and in some other cases, they vest them with a strong and active role. After the creation, and this is not quoting from your paper, after the creation of the Constitutional Court in Palestine in 2016, and the declarations of a state of emergency in Palestine during the pandemic, we are very interested to know about the role MENA constitutional courts play during this time, and whether a state of exception can be stopped by the constitutional courts. Therefore, your presentation and your work is very crucial to this panel and beyond. Thank you for accepting to be part of this panel. Now we are moving to Palestine, and it gives me a great honor to have Professor عاصم Khaleil. We are very, very happy to have him with us. He has been a true influencer to many academics and many scholars here with his work. And regardless if we agree or disagree on certain terms, I am one of the people who actually was honored to attend his class, even if I was not enrolled in Peers 8 when I was a student, and my students are also very honored to have him with us today. We are very looking forward to listen to his analysis about the case of Palestine, but I will give a little bit of brief, and then Professor Khaleil at the end, we will be honored for him to conclude this webinar before we go to the discussion. Thank you again, Professor, for being with us. So after giving the theory and the situation in MENA, we are going to move and discuss Palestine. The question if Palestine is an exceptional case or a state of exception is a relevant one. Given Palestine's unique circumstances, the former holds that Palestine, with its position as an occupied territory, as an entity without defined borders, with ambiguities concerning its nationhood and being spread across two territories, which is governed by two different authorities, will ultimately defy all attempts of categorization. The only danger of such an argument, however, would enable to justify any constitutional violations permanently. The state of exception, however, as we said, is a political legal concept to explore the Palestinian situation after the 2007 Fatah-Hamas clash that saw the use of emergency powers by the Palestinian Authority. The utility of the state of exception concept lies with its embedded notion of sovereignty that highlights the contradictions that emerge when spheres of governance are blurred together: the legal and illegal, the political and the judicial, and the public and private during periods of martial law or emergency status. Palestine has declared a state of emergency a few times since the start of the COVID-19 pandemic. However, the extensions of these declarations have lacked a constitutional basis. These state of emergency measures confirm how the normalization of exceptional measures is still ongoing. Ever since the Palestinian Legislative Council was suspended in 2007, following the election of Hamas, the legislative process in Palestine has been governed by the basic law under Article 43, the state of necessity. And you can discuss this further, Professor, to see if you agree or disagree. This provision required a very loose interpretation of what the basic law means when referring to the PLC, or the Palestinian Legislative Council, not in session, for it is only in this circumstance that the state of necessity can become active. President Abbas has since been using the state of necessity article to rule with decisions that have the power of law without any time restriction. In a slight then departure from a Gambian position in terms of the theory application, the Palestinian case suggests that the state of exception can also occur beyond the West. However, we have certain concerns when it comes to the state of exception application when it comes to Palestine. One of them is sovereignty and how sovereignty can be applied or understood in Palestine. We have certain concerns with the lack of a Palestinian parliament. We are asking for elections to take place in Palestine to go back to the normal situation, since Palestine is going through double transition, a transition to statehood and a transition to democracy. However, who is the actual sovereign in taking such decision? Who is the actual sovereign can end the exceptional circumstance? We have divided territory. We have asked for elections a few times, but even if the president is going for elections, can elections take place with Israeli restrictions? What is the role of the political parties? Are they still influencers as they used to or not? There are so many questions when it comes to the case of Palestine, and a major one is the role played by the Constitutional Court. Can the Constitutional Court interfere to end such exceptional circumstances? Or is it by dissolving the parliament created more vagueness and more issues than it should be? So many questions to ask and so many things to answer. Without further ado, we're gonna start with Professor Mabon. Symon, the floor is yours. Please start. And sorry for any time that I took. Please start.
Thank you so much, Sana. Thank you for the invitation. Thank you so much, Mona, for putting all of this together. It's wonderful to, I'd say, be back in Nablus, but to be virtually in Nablus. I miss you all dearly, and I look forward to the days of being able to visit again. And it's nice, obviously, to be sharing a panel with so many world-renowned experts on such really important and topical things. So I'm going to be talking a little bit about the theoretical underpinnings of Agamben's work. And this stems from an edited collection that my mentee and I are pulling together with Adel Rashid from Lancaster, but formerly at Al-Quds University, which is looking at the influence of Giorgio Agamben's work on understanding the Middle East broadly. But it's also speaking to some of the ideas that came out of a recent book that I had published by Manchester University Press titled Houses Built on Sand. And what I want to do what I tried to do in that book is to explore the source of sovereign power and how sovereign power and its contestation helps us to understand the contemporary Middle East as a perennial struggle, essentially, between rulers and ruled over access to the state, over access to the institutions of the state, control, the regulation of life, and ultimately over sovereign power. So that's what I do in the book. And in the chapter of this edited collection, which is broadly speaking what I'll talk about today, I try and set out some of the theoretical and conceptual tools that Agamben uses to help us understand what's going on. In Agamben's work, he sets out a theory of sovereign power and interrogates ideas of sovereign power across 9 different books, 9 different volumes of the Homo Sacer series. And these gained a great deal of prominence internationally after the attacks of September the 11th, due to his focus on the state of exception, emergency powers, the capacity of the state and indeed the sovereign to operate seemingly without restraint and to abandon living beings into what he termed a bare life. And it's been an incredibly insightful and damning critique of the excesses of sovereign power, but it's richly philosophical. But what I want to do today is introduce some of those ideas, some of those philosophical ideas, but show how these ideas that are fundamentally stemming from Agamben's own Catholic faith can be useful in helping us to understand the contemporary Middle East. And I'll start with a little story from Bahrain, a very sad story about a former sports journalist by the name of Eman Salehi. Eman was a sports journalist in Bahrain who was shot on the 23rd of December 2016 in front of her young son by a member of the Bahraini ruling family, the Al Khalifa. And what quickly happened was that the 34-year-old man who had shot Eman turned himself into the police. And the nature of political life in Bahrain meant that this act was passed on to a military tribunal, a military court, who launched an investigation, and there was later no charge. And what this does, I think, is demonstrate the ability of a ruler to exert sovereign power and to abandon a living being into what is termed bare life. for Agamben where an individual can be killed without any recourse to the law, where an individual can be abandoned from the protections of the law, yet forced to obey it. They're bound by the laws of the state, but yet have none of the protections of it. Now, what Agamben does is he says that this type of abandonment, this type of cultivation of what he terms bare life, stems from the emergence and the cultivation of a state of emergency. And going back to Bahrain, in the early months of the 2011 protests of the Arab uprisings, a 3-month-long state of emergency was declared by the king, which gave security personnel the ability to address the protesters without recourse to the rule of law. Essentially, they could do whatever they deemed necessary in order to ensure the survival of the regime. Now, the state of emergency ended in June 2011, but many of the features that helped to define and regulate political life at this time continue to remain in operation, helping to maintain and reinforce sovereign power. And that, I argue in the book and in this chapter, helps us to understand that what we saw with the suspension of the rule of law, the declaration of a state of emergency, it helped the Al Khalifa to embed a certain form of biopolitical regulation into state institutions, into the state, and allowing the state to move away from what was typically accepted to be the norm. And that shifting away from what was accepted to be the norm now is the exception, but the exception, of course, becomes the norm. So you have a state of emergency, which deviates from the norm. But when that deviation, when the exception itself becomes the norm, then we have the state of exception. And that is where Agamben builds on the work of a philosopher by the name of Walter Benjamin, who talks about this sort of deviation away from a reliance on the rule of law and the essential embodiment of emergency powers and emergency legislation as the status quo, as the new normal. And what Agamben does then is he presents this rich theoretical discussion of the source and mechanisms through which sovereign power operates in what he terms a new paradigm of government. And he talks about it as a fundamental relationship between rulers and ruled, and the ways in which the state of exception is central to an understanding of sovereign power. And it's essential in the sense that the sovereign prerogative, that ability to decide on the exception, is where emergency powers, emergency legislation, and sovereign power is located, at that intersection of public law and political fact. So the sovereign takes a decision on the basis of what is determined as or perceived as necessary, which then impacts on that regulation of life, on that ability to regulate life and ultimately regulate that relationship between rulers and ruled. So for Agamben, and I'm quoting here, the rule, suspending itself, gives rise to the exception, and maintaining itself in relation to the exception first constitutes itself as a rule. So then once that decision is made, it, having been suspended, gives rise to the exception and maintains itself through reconstituting it as a rule. So we have this emerging exception. Now, what Agamben also says is that whilst there's debate about the source of sovereign power, whether it's grounded within constitutions or beyond constitutions, Agamben suggests that it's the legal form of what cannot have legal form. It's a paradox. And anyone who's tried to teach and engage in discussions about sovereignty with first-year students and trying to put it in that most basic form will understand the sort of paradoxical nature of whether you're talking about inside or outside, internal sovereignty, international sovereignty. There are myriad different paradoxes that are built into the very concept of sovereignty, seen, of course, in how you conceptualize it, how you define it, where it's grounded in terms of its different disciplines. Is it about Is it about the law? Is it about a legal concept? Is it a political concept? Is it a religious concept? And I think for Agamben, those different paradoxes and those different points of contradiction are actually absolutely central in helping to understand the ways in which sovereign power operates. And he draws upon this paradox. He draws upon these different contradictions and suggests that the state of exception is a zone of anomie, a space that is devoid of law, and I'm quoting here, following the deactivation of legal norms and the collapse of the normal order. Now, here I think it's really interesting what he's saying, that the state of exception emerges when all of these things are deactivated, when they are stripped from what is perceived to be normal, when those legal functions, the rule of law, the regulation of life in accordance with what is perceived to be normal, are stripped out of all aspects of life, deactivated, legal norms deactivated, and normal order is collapsed. Then you have this state of exception. And he says that it's this preliminary condition for any definition of the relation that binds and at the same time abandons the living being to law. Now, what he's getting at there, of course, is this sense that you have this broader state of exception which exists in this zone of anomie and this space that's devoid of law. But within that, individuals are abandoned into what he terms bare life. He draws on ancient Roman history to talk about the individual that could be killed without recourse to punishment, but not sacrificed, to identify this figure of bare life. And the figure of bare life operates within the context of a state of exception, whereby anyone can be killed with impunity, following the collapse of the normal order. But what he talks about is this abandonment. The living being is abandoned to the law. They don't have the protection of the law, but they're bound to it. They're forced to obey the law, but they're abandoned from its protections. And so he talks about this as a broad paradigm of government used by states, regimes, sovereigns as a way of regulating life by placing bare life at the vanguard of politics. It's all about regulation of life here, the regulation of people. And there's a great deal of detailed theoretical, ontological discussion about the ways in which this operates. And perhaps I can make a quick plug for our forthcoming edited collection here. If you want to know a bit more about that, you can delve into some of those questions. But I think it's really important as a means of understanding both a vision for the political, and in that vision for the political, Agamben makes this distinction between bare life and the good life, drawing on Aristotle, whereby the bare life is that sense of natural life, and the good life being a life that has the full legal protection and status of a human being. And this is all positioned within broader biopolitical processes that regulate life. And I think it's a really useful way of shedding light on this relationship between rulers and ruled. Agamben used it to talk about the concentration camps, the Nazi concentration camps, and the figure of the Muslim in that. But more contemporary scholars have used it to describe a whole host of different contexts, be it the situation at Guantanamo Bay or Abu Ghraib, or the refugee camps of Palestine or of Lebanon. There's a whole host of different situations that can be used, that Agamben's work can be used to shed light on the conditions whereby individuals are abandoned into these conditions of bare life through the cultivation of a state of exception. Now, it's worth just stressing very quickly, because I'm conscious that I'm running out of time, aren't I? And I think it's worth stressing just that Agamben's work is obviously couched in his own Catholicism. He's writing embedded within a canon of Western political philosophy. He's a philologist, he's a religious scholar, but he doesn't deal with the non-Western world. But what I have tried to do in within a couple of articles that have recently used the Gamben is demonstrate that there are actually similarities and there are reasons for using a Gamben in the context of the Middle East itself. Although, as Sana said, it's not something that can be used purely to describe authoritarian rule, but it's something that can be used to describe the regulation of life in which states have the capacity to act politically, I think, and whereby that political life and that political engagement can be eroded, eviscerated, and removed from them, where they can be abandoned into this state of bare life. So I think there are good reasons for using it in the Middle East. And there's an article that I wrote with a former colleague of mine that looked at the state of exception in Egypt as a perennial mechanism of government since the time of Jamal Abdel Nasser, this declaration of a state of exception, a state of emergency that became the norm as a mechanism of regulating life, preventing the emergence of political agency that could challenge the rule of various political leaders from Nasser up until al-Sisi as a perennial status quo. But others have applied it in lots of different ways, lots of different disciplinary ways, including Sari Hanafi, John Nagel, Sara Fraganesi, Adam Ramadan, Ronit Lentil, and others, including the contributors to our book, who've shown that it can be used to shed light on legal processes, political processes, urban politics, revolution, resistance, the regulation of everyday life, urban planning. All of these different things can be interrogated through the use of a Gamben's framework, which fundamentally is concerned with the regulation of life in all its myriad forms. And I think that's where I should leave it. I'm sorry if I've gone over my time, but hopefully that helped to shed a bit of light on what a Gamben's trying to do. Thank you very much.
No, thank you very much, Simon, and thanks for promoting our book to a bigger audience than we thought.
We just have to finish it now.
Yeah, exactly. Thank you so much, Simon. And we move to Professor Nathan Brown. Professor, the floor is yours. Please start.
Okay, thank you very much. Thank you very much, Sanaat, for bringing us all together. Sanaat is a new friend. Actually, Simon was the one who introduced us to each other. And there are two slightly older friends, Franchesco, I've known probably about a decade or so, and Professor Caasim Khaleil, whom I've known for more decades than either of us would confess to. So I'll just say for longer. I don't want to say for how long. But it's an absolute delight to be with this group. And I'd also like to take this opportunity to sort of see what I want to be doing is taking some of the theoretical ideas and conceptual ideas that Simon talked about and give them very concrete meaning within Arab constitutional history. So I'm going to be talking about the evolution of Arab constitutionalism and emergency rules or states of emergency, how these two have grown up together. And in the process of making them concrete, I think some of the sharp oppositions that Simon was talking about, they don't disappear. But we see these two concepts as actually more closely intertwined, as historically they have been practiced than we might initially think. We often think of constitutions as limiting documents, as documents that say political authorities can do this, but they may not do that. They may make policy in this area, but they still have to observe certain rights, or they have to observe certain procedures and so on. And that they absolutely do. But there's something interesting about constitutions as well. If you look at them and the historical context in which they emerge, it's often the case that they emerge in states that are in crisis. And the early Arab experience with constitutions actually bears this out. If you look at when they were written, I would expand this to the Middle East as a whole, in Iran, the Ottoman Empire, as well as Egypt and Tunisia and so on, the early constitutional documents were written by states that were in crisis, and they were in two kinds of crisis, usually at the same time. One was a fiscal crisis. They didn't have enough money. They were trying to fight wars. They were trying to develop their economies and so on, and they simply didn't have the resources. And the second was an international crisis. They were threatened by European imperialism. They may have been bankrupt to European powers or to European bankers and so on. And so constitutions were brought forward in this period as a way to make the state more effective. We can the rule of law is absolutely something that can do something to guarantee citizens' rights. But we can also think of the rule of law not simply as a language of that states use to speak to societies or that individual citizens use to make claims on the state. Law is also the language that the state speaks to itself to say, this body is responsible for this and that body is responsible for that. And the feeling in many Middle Eastern political systems that brought in constitutions was that the absence of very clear procedures had led to all kinds of problems. Rulers who spent too much money, who borrowed without or irresponsibly and so on. And so that's the origin of constitutions. And I'm anxious to hear from my Palestinian colleagues on this, but my own understanding is Palestinian constitutional history is not the exception here. It is similar. If you look at when, for instance, the basic law was actually enacted in Palestine, it was a moment of profound crisis for the Palestinian National Authority. International crisis, absolutely, Israelis, and also by financial crisis as well. The Palestinian National Authority was dependent on sources of revenue and sources of aid, and so it needed to basically show that it could operate effectively and efficiently. So that's the, so constitutions are sometimes way
Professor?
Can I be heard now? Yes. Okay. I lost my connection for 30 seconds, and I apologize. But right at a dramatic.
Palestine, yeah. Once you start talking about Palestine, it's to make you in the mood. You had electricity cut. It's fine. We totally understand.
I see. Okay. So I feel Palestinian. Okay.
Exactly.
No, I should stay away from Palestinian. Not for electrical reasons, but because there's greater knowledge within the webinar on that. So let me return to the Arab world and talk a little bit about states of exception or emergency rules, states of emergency, and so on. And here I will give also a little bit of a historical view, anchored most of all in Egypt, which is a case that I know the best, but the Egyptian experience has generalized itself in the region. The first state of exception that I know of that was declared in Egypt was actually declared by the British in 1914. And it wasn't called a state of emergency. It was called martial law in English, or ahkam orafiyya in Arabic. And I give both terms because the English actually conveys the meaning of what the British thought that they were doing when they imported this device from other places in the empire, from Ireland and from India to Egypt. What they thought they were doing was essentially facing a situation of military crisis in Egypt at the beginning of the First World War, where Egypt had been technically part of the Ottoman Empire. They divide Egypt from the Ottoman Empire, declare protected over Egypt, and say we have to fight a war based partly in Egypt, and therefore we are placing the military governor, a phrase that exists in Egypt up to this day. Nobody knows where it came from or what it means, but the military governor has essentially authority to do whatever is necessary to provide for order. And the target was actually not so much Egyptian citizens, because the British occupation authorities had all kinds of ways of operating outside the law when it came to Egyptians. The target was foreigners who had extraterritorial status. under the capitulations. And let me here apologize to the translators who are facing all kinds of words like ontology and extraterritorial that I have trouble with in English. But I hope the meaning is clear. The citizens, if you were Italian, or if you were French, or if you were Greek, you were exempt from Egyptian law until the declaration of martial law, when the British military commander in the country, who was a general from the army, basically could do what was necessary to fight the war. The next declaration I know of, there were momentary, I think, declarations that had to do more with public health measures. But in 1939, again, Egypt is in a difficult position. It has a treaty of alliance with the United Kingdom that says that if the United Kingdom is at war, then Egypt is at war, or has to declare war. The Egyptian government cannot do that for political reasons. So what they did was to say, we're declaring martial law in the country, and in a way that we can mobilize the resources, suppress, for instance, any activity that's done by Germans in the country, and so on. So this, and the next declaration comes in 1948, and here, of course, Palestinians will know the significance of 1948. When Egypt again goes to war. But it was about at that time that vocabulary shifts from ahkam orafiyya, or martial law, to halat tawara, or state of emergency. And the process that Saimonn was just talking about of regularizing the exception comes into being. And it suddenly becomes, I shouldn't say suddenly becomes, it gradually becomes the case that what was happening in Egypt in terms of routine governance begins to operate through emergency mechanisms. For instance, in Egypt, if you charge too high a price for eggs, you can find yourself in a state security court. Why? What is the relationship between eggs or bread and state security? The reason is, of course, that in wartime, supply of public goods or basic goods is considered necessary for public order. But once this got brought into the system, the state of emergency became part of the normal Egyptian legal framework, so that even ordinary grocery shopping became operating according to emergency rule. And what I would say has happened, and here I'm going to narrate in historical terms for Egypt, the process that Saimonn just talked about, is that the exception became the norm. And it became that way three ways. Number one, states of emergency became permanent, or in a lot of countries, or they were declared and they just kept going. The second was that, and maybe we'll hear more from Franchesco here, who there was some reference to the procedural safeguards. Those procedural safeguards exist, but they have no meaning. They're hollowed out. So for instance, a parliament has to approve a state of emergency, but if the parliament only reflects the view of one political party or of a pro-government party, there's no effective check. There's more ambitious ways that governments have hollowed this out. The most extreme example I know of happened in the state of Kuwait, where the emir at 2 occasions suspended the parliament. Now there's an article in the in the Kuwaiti constitution that says in a state of emergency, parliament cannot be suspended, nor can any of the articles dealing with the basic structures, basic freedoms be suspended. So what did the emir do? He suspended that article. So if you can suspend this, I mean, this is the emergency within the emergency within the emergency, it begins to hollow out any kind of structures. And the third way that states of emergency become normal is insinuating themselves or becoming part of normal legislation. So for instance, when states of emergencies lapse, it often is the case that nothing changes because I mean, you could say that the exceptional mechanisms are so thoroughly a part of the fabric of law that it would take almost a generation going law by law to root out the ways in which the law is ambiguous, empowers authorities, and so on. So let me close by a little bit of a constructive note. What has to change for constitutionalism and emergency rule to be separated a little bit in the Arab world? I think one thing, and probably the most important thing that would have to happen, would be some restoration of pluralism to the political process, the constitutional process, right? If you have a political order in which multiple political forces are operating within the state apparatus, in the parliament, for instance, you could have some of these effective oversight mechanisms restored. The ones that exist on paper might be able to operate in practice. In the Arab world today, I see a few places where that might be possible. Kuwait, when the constitution is operating, and it was suspended for 2 periods, but when the constitution is operating, can do that. Tunisia today has that kind of pluralism represented in the parliament. Palestine, for a brief moment, did have that kind, I should say for an extended moment. I would say the first Palestinian Legislative Council was certainly dominated by Fatah, but there were all kinds of political forces within it. And the second Legislative Council, when it existed and operated for a short period, may have been able to do that. I don't see that sort of situation operating very well in the Arab world. The only time that the state of emergency lapsed in Egypt since 1948, there was a very, very brief period in 1981, but essentially it was when you had political pluralism in Egypt in the brief 2011 to 2013 period. So that's the first thing that you need. The second thing that you need, I think, is almost a shift in constitutional doctrine. And again, there are people here who are better at talking about doctrine than I am. But I noticed when Professor Saimonn Mabon was speaking, he spoke a great deal about sort of sovereign power. And if you look constitutionally in most of the Arab world, the sovereign power is sovereignty resides in the people, in theory, but in practice, it effectively resides in the head of state. And you see this in a constitutional doctrine that places the president almost at the top of the constitutional order, but effectively outside of it and above it. And you see that in doctrines like the doctrines of acts of sovereignty. And so I think you need some kind of doctrinal shift, and that's work that can be done, I think, by intellectuals, including some of the ones whose faces I see on the screen right now. And then the final thing that you need is probably a long process of examining normal legislation, because once, as I say, once the state of emergency ends, there will not be some sort of magic transformation to a system in which normal constitutional rules prevail. Instead, what I think would have to happen would be a long process of reviewing legislation so that things like grocery shopping, I mentioned in Egypt, or all sorts of normal activities, press and publication and so on, the role of the and the authority of the security services could be carefully reviewed by a pluralistic body within the society that could actually say, this is what we want these bodies to be doing, and these are procedural safeguards that we wish to have followed. Those aren't effectively written, I think, for most Arab countries, because the laws governing such things were written almost with the mindset that I just talked about, that of the essentially the executive being technically part of the constitutional order, but effectively being above it. Thank you.
Thank you, Professor. That was amazing, actually. And I can see that I would like to encourage the students, instead of writing us emails to the website or the center, to put it in the Q&A, because you have at least 6 questions that came via email, apart from the one that you have here. So thank you so much, Professor. And we move. And thank you also for putting this amazing summary about the situation in MENA region and adding the Palestinian situation that will be discussed later on as well. We move now to Francisco. Francisco, the floor is yours. And thanks again for all your work that has been translated. And I'm sure the students, they are familiar with you from the things that they've read. Please, the floor is yours, Francisco.
Oh, thank you very much, Sana. So first of all, let me thank more generally, all the organizers of this workshop for inviting me. So Al-Najah University and in particular the Constitutional Studies Center, and obviously my dear friend and colleague Sana. It's really a pleasure and an honor for me to be here virtually with all of you. I have to say that it's quite tough to intervene after two giants such as Saimonn and Naathán, but I will do my best. So as Sana mentioned in her presentation, I will talk about the role of Arab constitutional courts in times of emergency, and I will try to give you a comparative perspective, a comparative overview. My presentation will be structured, will be divided into two main parts. First of all, I will examine the role played by Arab constitutional courts in reviewing the declaration and extension of the states of emergency, whereas in the second part, I will discuss some rulings of Arab constitutional courts regarding the exercise by the executive branch of emergency powers. The first thing that I would like to stress is that most modern constitutions do not grant, at least explicitly, any role, neither to ordinary courts nor to constitutional courts in the process leading to the declaration and extension of the state of emergency. And from this point of view, Arab constitutions are certainly no exception. As I will show in a second, only a few of them explicitly grant a role in this field to constitutional courts, but the majority don't. The case of Egypt, I think that from this point of view is particularly important, because in Egypt, courts have never been granted the power to review the declaration or the extension of the state of emergency. In a very important judgment that was delivered the 3rd of April, 1976, the Supreme Court, because at the time the Constitutional Court did not exist, so the Supreme Court argued that it could not review the declaration of a state of emergency because the proclamation of a state of emergency was an act of sovereignty. Amal al-Siyada, Naathán was referring to it a few moments ago. So an act of sovereignty is, as we all know, an act of the executive branch that falls outside the jurisdiction of the judiciary. And this category of the acts of sovereignty that in part recall the political questions of the US Supreme Court was and is still often invoked by Arab courts when they want to give wide discretion to the executive branch. So the fact that the Egyptian Supreme Court relied on this doctrine in order to avoid to rule on the presidential declaration of a state of emergency is certainly far from surprising. I have to say that there has been quite recently a very important innovation that maybe it has been a bit underestimated, because this non-justiciability doctrine of the proclamation of the state of emergency started to change in Egypt, even if only partially, in 2013, when the Egyptian State Council delivered a judgment allowing a limited review of the formal requirements of the proclamation of a state of emergency, in particular, the duration of the emergency and its geographical scope. And although the State Council continued to grant a wide discretion to the executive, still this decision was a very innovative one because it partly departed from a consolidated case law. So for the first time in Egypt, the declaration of a state of emergency is not entirely considered as an act of sovereignty. Then other Arab constitutions now obviously I'm referring to post-Arab Spring constitutions. So other post-Arab Spring constitutions only grant a weak role to the Constitutional Court in the process of declaring or extending the state of emergency. And this is, for example, the case of Morocco and Algeria, where the constitution stipulates that the head of state, so the king in Morocco, the president of the republic in Algeria, can proclaim the state of emergency only after having consulted certain institutions, including the president of the Constitutional Court. Why do I say that this is a weak involvement of the Constitutional Court? Because the opinions delivered by the Constitutional Courts are non-binding, and therefore the head of state is absolutely free to disregard them. So the executive branch continues to have the final say when it comes to the declaration and extension of the state of emergency. And finally, we have the case of Tunisia, which really represents an exception in the Arab world, because the Constitutional Court has been granted a strong, an active role, because it has been vested with the task of reviewing the constitutionality of the extension of the state of emergency. So this means that the Constitutional Court has the power to terminate a state of emergency proclaimed by the President. Article 80 of the 2014 Tunisian Constitution identifies the conditions under which a state of emergency may be declared, and stipulates that the President of the Republic may declare such a state only after consulting the head of government, the Speaker of Parliament, and after informing the President of the Constitutional Court. But moreover, and this is the real innovation, the most important part, 30 days after the entry into force of the exceptional measures or the emergency measures, and at any time thereafter, the Speaker of Parliament or 30 members of Parliament have the power to apply to the Constitutional Court with a view to verifying whether or not the circumstances are still exceptional. So 30 days after the declaration of a state of emergency, the Constitutional Court in Tunisia is in the position to review such a state, and if necessary, to stop it, to terminate it. Unfortunately, as we all know, the Tunisian Constitutional Court has not yet been set up, and therefore it has not been able to review the state of emergency, which has been in force in the country since November 2015. The Tunisian drafters clearly relied on the constitutional reform that was adopted in France in 2008, which granted to the Constitutional Council the power to review the extension of a state of emergency. So in the case of Tunisia, we are clearly dealing, with a French influence. But now I would also like to say something regarding the rulings of Arab constitutional courts regarding the exercise by the executive branch of emergency powers. And here the first aspect that must be stressed is that usually the cases in this field did not even reach the Constitutional Court. And this was due, among other things, to the problems related to access to constitutional courts, so to the procedural gateways to the constitutional courts. And in fact, in a number of countries before the Arab Spring, constitutional standing to refer cases to constitutional courts was extremely, extremely limited. And this had the obvious consequence of drastically reducing the overall number of legislative acts on which the courts could rule. Just to give you one example, in Tunisia, under the 1959 Constitution, the President of the Republic was the only authority entitled to apply to the Constitutional Council. So there was really, I would say, a stronghold, on access. But even when the cases concerning the exercise by the executive branch of emergency powers did reach constitutional courts, sometimes these cases were not resolved and remained on the court's docket for a long time. In Egypt, for example, the case concerning the constitutionality of Article 3 of the 1958 emergency law, which stipulated that whenever a state of emergency is declared, the president has the right to issue a verbal or written detaining order or search warrant without being restricted by any of the criminal law procedures and guarantees. Well, this case remained on the docket of the Constitutional Court for 20 years, from 1983 to 2013. So the court reviewed its constitutionality all in 2013 and decided to strike it down. Obviously, declaring the unconstitutionality, of this article is a positive innovation, is certainly a good news. But we also have to consider that there were probably political reasons why the court made this decision precisely in this period of time. It was a period in which the Muslim Brotherhood was in power, and there was, for various reasons, quite a serious confrontation between the Brotherhood on the one hand and the Constitutional Court on the other hand. And even when the constitutional courts did immediately check the constitutionality of the emergency measures, usually these measures were declared in line with the Constitution. And I think that, again, Egypt is quite an interesting example, because during the 80s, the Constitutional Court was asked to rule on the constitutionality of a legal provision that denied the defendants the right to appeal rulings of emergency state security courts in the regular judiciary. And in particular, it was argued that this provision violated the right to a due process. However, the Constitutional Court stated that state security courts were constitutional, were in line with the Constitution, and that there was no violation whatsoever of the right to a due process. I want to stress the fact that the Egyptian Constitutional Court maintained this very differential approach towards the executive branch in the field of emergency powers, even during the so-called golden age of the Constitutional Court. So basically from the mid-80s to the end of the 90s, and in particular when the court was under the presidency of Chief Justice Elmore, who promoted quite a liberal, quite a modernist, interpretation of Sharia with the aim of strengthening the protection of fundamental rights, including sometimes even women's rights. But the emergency powers of the executive branch represented a field in which the court, even in that period, gave to the executive almost full discretion. And to conclude, with adoption of new constitutions after the Arab Spring, there has been an attempt to limit the almost unlimited prerogatives that the heads of state enjoyed in times of emergency. The role of parliament has been partially reinforced. Some new safeguards have been introduced, and maybe during the Q&A I can say something more about these new safeguards. But my impression, however, is that generally speaking, so apart from a few exceptions, Arab countries are still characterized by a Schmittian approach, whereby sovereign is he who decides on the exception, according to the super famous expression of Carl Schmitt. So what I want to say is that the presidents and the kings in the Arab world continue not to be particularly limited by the principles of constitutionalism, while declaring or extending a state of emergency or while exercising emergency powers. On the contrary, I have the impression that they still enjoy in this field an excessive degree of discretionary power. So again, my impression is that the idea of Carl Schmitt, according to which all decisions pertaining to emergency powers are political in nature, and therefore in these circumstances, law must cede to politics, this idea is still, in my opinion, very much present in today's Arab world. But there are some positive news, and I would like to conclude on a good note. The ruling of the Egyptian State Council of 2013 that I mentioned before, which for the first time did not consider the proclamation of a state of emergency as an act of sovereignty, is certainly a very important news. And moreover, some new Arab constitutions now follow a more, I'd say, Kelsenian approach. So they explicitly recognize that even in times of emergency, mechanisms of checks and balances must put in place. And the case of Tunisia that I was talking about, I think, is the most emblematic example. As I said, the constitutional drafters decided to vest the Constitutional Court with the power to review the extension of the state of emergency. And in my opinion, this is probably one of the solutions, one of the paths that even other Arab countries could take into consideration in order to stop the perpetual renovation of the states of emergency or the state of exception that has thus far been the norm in the Arab context. Saimonn and also Naathán were talking about the fact that the exception has become the rule, according to the very famous expression of Giorgio Agamben. The reason why I'm saying that I'm arguing, in favor of a more active role of the Constitutional Court is because there are some interesting historical demonstrations that this could be quite an effective mechanism. In Colombia, for example, the 1991 Constitution stipulates that the government must submit to the Constitutional Court the decrees proclaiming the state of emergency on the day following their promulgation, so that the court may decide on their constitutionality. And should the government fails to do so, the Constitutional Court has the power to review them automatically. You have to know that between 1991 to 2011, the president, the executive branch, issued 25 decrees declaring a state of emergency, 7 of which were annulled by the Constitutional Court. So in Colombia, the court has managed to prevent the president from abusing his power to declare a state of exception. I already know what the criticism could be. One might argue that since constitutional courts in the Arab world, in most of the cases, have not exercised their counter-majoritarian role, but they have been instruments, they have been tools in the hands of the executive branch, granting them an active role during a state of emergency would be a risk, because the constitutional courts could give a constitutional veneer to the decisions adopted by the executive branch. They could provide a constitutional justification for the abuses committed by the executive branch in times of emergency. This risk exists. It is evident that it's there. I think that no one can deny it, and I don't want to undermine it. But I believe that in the light of the fact that in the past, kings and presidents in the Arab world have systematically abused of emergency powers, probably it is worth taking this risk. Thanks a lot for your attention. Shukran.
Thank you, actually, Francisco. So many questions from this presentation, a little bit controversial at the end, and especially with you being extremely positive about the role played by the Constitutional Court in Egypt. But I wouldn't interfere in this. I would leave it to Professor Brown if he wants to add at the discussion section. And also when it comes to the term limit of the president and the role played by the court, I don't know, but I wouldn't interfere in Egypt. We will move to Palestine. Thank you so much before that, Francisco, for this interesting presentation. And I have to highlight that Saimonn is with us and he keeps writing, just his internet is not very stable, so he put the camera off, just to clarify. Also, we are moving now to Palestine from the note of you, Francisco, saying the sovereign is that who decides on the exception. Is it the case in Palestine? The Constitutional Court should have active role in the state of exception, also driving from what you said. Should it be the case in Palestine? And also from Professor Brown's, the exception above the exception above the exception when it comes to the MENA region in certain cases. Is it the case also in Palestine? And is it the case that we are indeed in a state of exception while we twist the theory that Saimonn talked about? We leave you now with Professor عاصم Khaleil. The floor is yours, Professor.
Here we go. So the last session, I think everybody is tired already to listen to more talk, but I have to do it, so forgive me. So the ambitious title I have provided for this presentation is not exactly what I'll be covering. It's a part of a bigger research project, and this presentation, and I look forward to receiving feedback, maybe to be part of the full paper. Now, I have 2 preliminary notes, 3 examples of research I have done and I think it didn't work, and 3 ways forward I suggest for future research on matters related to law and constitution in Palestine. So rather than taking it right now as a reflection of a fully developed paper, it's sharing my experience more than presenting a full academic paper. The 2 preliminary notes I would to start with is that this is a paper about the right inquiry method, and it's about the theory itself. Is exactly how to think Palestine and how to think law in Palestine and how to think about constitutions and their role in Palestine. So it's often the case when we teach in legal education, legal studies and research in Palestine, is that we don't care much about theory. Of course, the fact that the overmajority don't care about theory makes our life harder when we want to work on theory, but it doesn't mean it's less interesting or less important, because I believe theory provides us with a framework that enables us to speak the same language, or otherwise, if it doesn't help us to speak the same language, it helps us understand each other and communicate better. It is often the case, conflict arises between people even speaking the same language because they use different theoretical frameworks. So that's why theory and a method may help us revisit the questions usually we ask when we study Palestine, the law and the constitution, and the role and the rule of law in Palestine. The second preliminary note, it is that it is often the case in my own research projects, and I believe many other researchers have done the same, is that I exclude certain approaches to law and constitution rather than offering a positive narrative in the way I believe we should approach law and constitution and the way we study them. Because the way forward cannot be my way or the highway. It is rather a work in progress, I believe, approach to the study of law in Palestine, where a theory and the method is developed while we're doing it, not a priori. Following this 3 ways I tried doing research on Palestine, and I believe it didn't work. It's no more satisfactory for me. The first one is I tried legal positivist approach, including its version of legal realism, to see why the basic law of the Palestinian Authority didn't work. I concluded my research by suggesting the dangers of adopting a positivistic and legalistic, formalistic approaches to law in Palestine. And I concluded often by inviting other researchers to reconsider the way and the questions they raise, and having people at the center rather than the state in any debate about law and constitutions, and even about human rights or about fundamental rights generally. The second approach I tried and it didn't work, it's no more satisfactory, is legal pluralism. I dealt with this in the cases of informal and tribal justice in Palestine. I tried to include the colonial aspect when dealing with both movement of population and borders control and the determination of who is foreigner and who is resident since the Israeli occupation in 1967. And in other research, I even went back to the British mandate, where some focus on Palestinian citizenship showed that what we are attached to as point of reference for Palestinian nationalism and Palestinian citizenship is actually a British mandated citizenship law that encourage the Balfour Declaration and the realization of homeland for Jews. So this legal pluralist approach, I believe, is no more satisfactory for me. The third approach I tried is the focus on how law, including the constitution and constitutional arrangement in reality, were at the same time colonial, occupation, foreign tool of control, oppression, or domination. At the same time, I was perplexed and still am. I did some research to follow this, to notice that the overwhelming theoretical and practical attachment to law and constitution in Palestine, whether by Palestinians themselves or by those supporting Palestine through even financial aid to rule of law programs and democratic government. For all of those, talking law should be separate from talking politics, or they argued, because politics, it's outside the framework of what we lawyers and jurists should take care of. Law and legal enactments are the only juridical phenomenon we should take care of, because law is good, politics is bad, politics is unjust, law is just, politics is about facts, law is about norms. So in a sense, I was asking myself, and that's why it's no more satisfactory, this kind of approach, what if all those categories are in reality messed up? And what if what one considers as outside the juridical world is in reality embedded within it, at the center or even at the margin, as a company would argue, of the juridical world, but still very relevant and fundamental for it. So the 3 approaches, I finished the 3 approaches I tried and didn't work. The new 3 approaches I suggest I'm now interested in them and recommend others to work on them, taking the example of COVID-19 emergency situation to consider. And one of them, of course, is what was presented so far about Agamben theory of state of exception. And I'm aware, and as was mentioned before, that some consider that this state of exception is inadequate as a theoretical framework, both to qualify Israel and the Palestinian Authority. One was mentioned before is about the Eurocentric approach that one can find in Agamben, and the lack of interest or coverage of the experience from the perspective of the colonized, from the perspective of those under domination and under settler colonialism. And in that sense, one reading of Agamben's theory of the state of exception is to consider it as a critique to liberal constitutionalism, similar possibly to Schmidt before him. But the other critique to Agamben theory, I didn't hear before, but I refer to it right now, is that when we use the state of exception, even it gives the impression that we are sliding away towards more illiberal democracy through the state of exception, while is, however, and remains, for those who criticize Agamben, remains a reflection of a Western, but also is only a sliding away of the rule of law. This is why talking about Israel as a state of exception, for example, is welcomed by many Israeli scholars, Zionist scholars, because this is an indirect recognition that despite this sliding away, Israel, as much of the world right now fighting terrorism, is a democracy and a liberal one, but forgive our illiberal approach, a temporary one. We are in a state of emergency, and that's why this state of exception is taking place. So while talking about the state of exception of Israel, we are confirming indirectly that it is a liberal democracy that is a little bit sliding away from it. So some authors consider this as not enough. What if this is simply a misleading theorizing about Israel and about Palestine also, which is now increasingly referred to as a state with a small s within the Zionist state with capital S. So is the state of exception in that sense a good framework for us to discuss about Israel, and indirectly too about the state within the state, that is about the Palestine that we are interested in. The second approach, I believe that there is a need to reject premises or assumptions related to the rationality or circularity or comprehensiveness of the legal system. This includes the need to look at emergency and exception from below. That is, not from the perspective of who decided, with due respect to Agamben and Schmidt before him, about the sovereign who decide the state of exception, but look at it from the perspective of those who suffer as a result of it. What we see there, if we take it from bottom, not from up, is a completely different view. It's not unity, it's multi-layered regime of exception and emergency, and where the BA state of emergency that many scholars are interested in is just a very tiny minor issue, and mostly not the effective one or the relevant one when we talk about the state of exception in Palestine. The third approach, there is finally a need to rethink those state-centered framework of analysis based on sovereignty, not because of limited sovereignty, as most contemporary states, one would argue, have limited sovereignty anyway, but because of the absent sovereign in Palestine, where law and legal enactments are understood not as enhancing rights, but as limitation to those rights, while the one who's limiting them is not there. The sovereign is absent. People suffer just those limitations without knowing the source of those limitations exactly. Who is that sovereign? He's absent, he's not there. So rather than multiple sovereigns, as is often the case, or limited sovereign, following other recommendations, I suggest we think about law and constitution in Palestine in the absence of a sovereign. To use a successful image, I believe, reflected in a title by Ronald Dworkin, when he talked about, in a posthumous book that was published, Religion Without God, I invite to think about constitutions, about law in Palestine without the sovereign. Of course, in constitutional theory, as by the way, for religion, when they read the book about Ronald Dworkin, this is heretic. how can we talk about constitutional theory in the absence of the sovereign? But I believe this to be a necessary step to undertake in order to understand and to find analytical tools to understand law and constitution in Palestine. Two comments as concluding remarks. One, the importance again for such theoretical and methodological approaches to law and constitution in Palestine is not in their capacity to offer better responses to questions that often lawyers ask. I believe that there are good answers often offered around by interesting lawyers and jurists, including possibly opinions and decisions that the recently formed Supreme Constitutional Court in Palestine is contributing to. Rather, my suggestion is that those approaches may help us ask the right questions about law and constitution and its role in Palestine, rather than continue our useless argument about the responses we are giving to the wrong questions. The second point of conclusion is that those frameworks suggested above do not have the mission to offering ways to overcome the status quo. I believe theory doesn't have that task. The task of a theory is at worst to help us understand and at best to offer a little bit more adequate tools of analysis in order of the status quo. I personally can attest that based on my own research, that the analytical tools I used so far didn't work. It's time for me to look for alternative tools, and I invite you all always to revisit our analytical tools. Thank you very much.
Thank you very much, Professor Khaleil. And I think we have so many questions, even like to ask you. I mean, I don't want to dominate the conversation now and go like with certain things that you mentioned, but I would like to leave it first to the questions. And I think maybe Symon will be the best person to comment on the absence of sovereignty and the application of Agamben and the space that you talked about. But before that, I know that Professor Brown has to leave soon. It's a shame, but we have so many questions from the students. So if you allow me, I will start. Would you like to answer the questions, Professor Brown, that is directed to you? And of course, if you can stay with us for extra few minutes until we get a little bit of discussion, that will be great. But of course, I'm aware that you already informed us that you have to go. So Professor Brown, I think there are at least 5 questions directed to you. Do you want me to translate the Arabic ones?
No, I can read them.
Oh, yeah, of course.
Yeah.
I apologize.
Yeah, no, but I'm going to answer in English.
Okay.
But I can understand the questions. I do apologize. I do have to leave sharply at 11:30. So what I want to do is to take some of these questions and maybe answer them jointly, but also in ways to draw on some of the things that the other panelists said. So essentially, I'm going to perhaps, there's one question I think that is behind these questions, and also behind an awful lot actually of what Professor Asim Khaleil just said, is is there any way that constitutionalism can be a path out of Palestine's political predicament? Just a quick comment about what Professor Asim Khaleil said is some of the approaches that you say you have abandoned, I think, are probably still worth keeping parts of alive, right? You talked about the idea that sort of recentering it to the people, looking from below. I guess that was also in part of your new approach as well. When I look at the Arab world, when I see when constitutionalism has been a path partly out, it has been when publics within the Arab world have embraced constitutional debates. I talked about Kuwait as being partly an exception, and then Egypt during 2011 and 2013. And what these exceptions have, and to some extent Tunisia, yes, they have political pluralism, in common, but they have something else as well. And that is that various political actors and in fact broad societies embraced constitutional debates as central to politics, as part of politics. And that's something that's been missing in a lot of the Arab worlds, the idea that constitutions are a luxury for other countries that we cannot afford. And in that respect, I would say that the Constitutional Awareness Campaign that I'm hearing about, the number of attendees at this session, is actually a very healthy sign. When people are speaking their political concerns and agendas in constitutional terms, that's a way of them coming together. And again, on your Professor Asim Khalil's idea of constitutionalism without sovereignty, it reminds me a little bit of Andrew Aratu's post-sovereign constitution making. And in essence, that's sort of what it's getting at, is not assuming that there is a single sovereign entity, a state or a people, but understanding politics is actually people with diverse interests and diverse groups trying to come together and act coherently, manage their differences, but also act collectively. And that kind of image of constitutionalism, I think, would be a healthy one. And that leads me to the answers to some of the questions here. I guess I would address Osama Aid's and Athira Jawda's to some extent, who asked about the division and elections and so on. Mesa Khalid's to some extent. So I talked about what kind of viewing what the Constitution is, and is the Constitution sort of, as I just described it, a luxury, something for calm times, something for settled political systems, or is it something that can help a society and a political system in crisis? When I was doing most of my research on Palestinian politics, which was back in the late 1990s and early 2000s, a lot of Palestinians use this phrase, min ath-thawra ila dawla, from the revolution to the state. The Palestinian politics was passing through this, and then unfortunately discovered dawla wasn't there yet, the state wasn't there yet, and the thawra continues year after year after year. But not seeing those as separate. In a sense, that was the attitude of the late president, Yasser Arafat Abu Ammar, who essentially, I think, sort of took the attitude that Palestine was in a critical situation, and the last thing that it really had the luxury to do was to construct normal political institutions, that you needed to have an authority that unified the entire people, Palestinians in the diaspora, Palestinians in Palestine, and confronting all the numerous challenges. And the people who wrote and pushed and secured the passage of the Basic Law took the opposite idea. And I'm not Palestinian. It is not my role to make recommendations for Palestinians. But were I Palestinian, I would find the second view much more convincing, that in essence, the Palestinian political system is severely broken now, and it's broken for all kinds of reasons. But one of the main reasons is that there are no real authoritative structures who can speak for Palestinians or have them act coherently. That has to be addressed, and it cannot be addressed any way that I know of without using constitutional devices in some way. Constitutional devices, and actually even at some point electoral devices. To get at the question about elections in this context, good, clean, normal elections are impossible right now, right? They would need international support, they would need Israeli support, they would need Palestinian support. And so you simply cannot have them right now. But to have some kind of mechanism in which Palestinian people can speak and have the plural voices result in a leadership that represents the broad array of political opinions and political views in Palestine, and have them come together. Constitutions can provide, looking at a constitution as a device that can help that happen, I think would be a salutary step. And let me finally and here I will have to end on this note, and the remarks, and there was a question as well about the Palestinian Constitutional Court and to some extent the Egyptian Constitutional Court. I think the Egyptian Constitutional Court had a tug of war, which we heard a little bit from Franchesco Bيaجي, and I would say the Egyptian judiciary as a whole, right? Is it something that stands for the Constitution and for the state as a whole, or is it something that, in essence, stands as defending order from chaos? And it's interesting in this regard. The recent Chief Justice of the Constitutional Court, Abdulwahab Abdulrazak, was a person who drafted some of the opinions that were part of the golden age of Awad al-Morris chairmanship of the Constitutional Court. He was recently elected Speaker of the Egyptian Senate, which is a body that is going to be very loyal to the regime. So how do we understand that a figure who was a pillar of the Constitutional Court in those days is now basically supporting the regime? And I think what has happened essentially is that in a situation of political crisis, some key actors view themselves as supporters of the regime rather than supporters of the state. And if I'm much less familiar with the Palestinian Constitutional Court, but my concern is that is where it is starting, as seeing itself as representing this revolutionary idea that it is to defend the revolution and it is not to defend the emerging state of Palestine. And that is an understandable attitude. It's difficult to say that they are that they are wrong, that Palestine doesn't need this kind of unity. But I suspect that Palestinians will come to regret that the Constitutional Court took this attitude, and one that was far more willing to hold the executive accountable and to be a force for those mechanisms that still exist, even if they've gone to sleep, but they still exist on paper in Palestine, that provide for democracy and the rule of law. I think a later generation of Palestinians will wish that that's what they had done. And maybe now at this point that I've criticized the Constitutional Court, maybe this is time for another cut in electricity. Because I don't want to be rude and tell Palestinians what they should be doing, but those would be my thoughts. And I'm sorry I have to leave on that note.
Professor, thank you very much. I know that you have to leave, and we have so many discussions that we need to say about what you just mentioned in the last 2 seconds. I think, and the interpretation of the court, but maybe that's for another panel. Thank you so much, and thank you for addressing the questions of the students because they were eager to ask you. I will definitely pass any questions that they will post as well. And it's as I said, it's unfortunate because we wanted to have more discussion with you, but we're aware of the time that you have. Thank you deeply, but
okay.
We should have a discussion about the interpretation because that's quite controversial. Thanks again. And we will see you very soon, hopefully in the future.
Okay. Alf shukra wa ma'asalama. Okay. Bye-bye.
So on that note, Professor Brown is leaving us, and we continue the questions and the discussion. I think before there is a storm in UK and the electricity keeps cutting. So I would like to leave Symon to answer, or I think he would like to answer something about the state of exception and the absent or the multiple sovereignty that Professor Khaleil was talking about. So the floor is yours, Symon, to respond to that.
Thank you, Sana'a. I must apologize. The internet here is cutting out as we endure what is looking to be an epic storm. So many apologies. Yeah, I found your comments, Professor Khaleil, fascinating. It's always interesting coming up against critiques of Agamben. And I share many of your frustrations, particularly with regard to the lack of agency, which is a big issue that I've had with Agamben. And it's one that he's actually started to address, and some of the recent work on Agamben has started to address that with regard to a concept called destituent power. And I found this was really fascinating. A colleague of mine, John Nagel, has written about this with regard to Lebanon. And what he's trying to do with destituent power concerns the deactivation of the very functions of sovereign power that are preventing individuals from escaping the conditions within which they are in. So he's not necessarily talking about a violent form of resistance or anything like that. He's purely talking about deactivating, preventing the things that are put in place to stop you from achieving what you want, from preventing those from taking place. So what John has explored in the Lebanese context concerns minority rights, LGBTQ rights, and the ways in which these human rights organizations have worked with lawyers, civil society organizations, local judges.
I think we lost Simon, but it's okay. His work is still there, even if there is a problem with the internet. I think what Simon's trying to say is that commenting on the points that you were mentioning, Professor, that there is also the other aspects of Agamben theory that he completed with, and the distinction power. And I will be happy to pass the paper of Nigel to you. In addition, but I don't want to complete Simon's words because I don't know what he's going to say next. So on that note, we can continue with the questions. Francisco and Professor Khaleil, shall we continue with that? There is one thing I have to translate to Simon. Sorry, to Francisco, because it's written in Arabic. Can I, Francisco?
Sure, please go ahead.
So I think the rest are written in English to you and to Professor Khaleil, and there is one also. Well, today I'm sharing. I'm not going to give my views. So there is one from Zaina. There is two actually. So, okay. My question to Professor Biyagi is that, okay, Simon, are you back with us? Okay, you can continue with the Professor Khaleil.
Yeah. Thanks. So sorry. These storms. So yeah, it was about deactivation. But so I hope that kind of made sense. I'm not an expert on Palestine, I should say. But I wonder if there are ways that could operate in the Palestinian context. And I just had two other quick remarks, if I may, Sana'a. One is about why should we even use Agamben? And I think what Agamben does, and I appreciate it's a top-down approach, but from my understanding of Agamben and from talking to Palestinian friends and colleagues, what Agamben can allow us to do is to dismantle the structures of power that are putting us and regulating life in particular ways. And when using it in the Palestinian context, it allows individuals to deconstruct the different modalities of power that operate. So obviously there is this Israeli set of conditions that operate and impose the occupation onto Palestinians. But then within that, in a form of what perhaps could be understood as nestled sovereignty, is the PA, which is operating with its own set of legal guidelines, structures. And what one of my PhD students has argued is that there is actually a second state of exception, operating within the Palestinian Authority with regard to its treatment of particular groups, notably in East Jerusalem. So there's this double state of exception, the Israeli imposed state of exception, which is far harder to deactivate, of course, and requires a whole host of issues and responses that we certainly can't address here. But then the second state of exception, the one that's imposed from within, from the PA, is actually perhaps far more easy to deactivate using some of the things that Nathan, Francesco, Sana'a, and yourself have pointed out with regard to the role of a constitutional court challenging sovereign power, the quote unquote sovereign, even if there is no explicit sovereign in place. And here, if I may draw the parallel with Lebanon, Lebanon is obviously this fascinating state that many suggest doesn't have this overarching sovereign power. But there's been a really interesting body of work done that suggests that sovereignty is actually found in the power sharing agreement itself. So in conversations with Sana'a, there's the suggestion that maybe the sovereignty is found in the basic law, perhaps. So maybe sovereignty is located in different places in the Palestinian context. So figuring out how to navigate that is, I think, one of the strengths of an Agambenian approach, because that can help us to identify, untangle, and figure out how to deactivate those structures of power that are having such a devastating impact on people's lives. Now, I should just stress again, I'm not a Palestinian expert, nor am I Palestinian, although some of my friends, my dear friends, are Palestinians, and I've spent time there. But that would be how I would understand it. So I hope that kind of made sense in spite of the storm break.
No, I think it makes, I cannot say much because I think continuing on what Saimonn was saying, we worked a lot on the idea of sovereignty and how to apply it when, you know, there is no clear sovereign in Palestine. And I think Professor Brown was talking about it when he said even elections will have certain restrictions, and even when we start talking about it at the beginning. But still, does it really mean that we cannot apply this approach to Palestine? I think the twist that Saimonn has been working on for the past 6 years, I think, on Agamben theory and how it applies to MENA region can also be applied in the context of Palestine, especially when we look at distinction power and how it can be applied. And, you know, and how can the Constitutional Court, regardless of not us being agreeing with most of the decisions, how it could be used as a tool to stop the exceptional circumstances or the state of exception, and actually to find the moment of time when the state of exception actually occurred. Thank you, Saimonn. And I will try to move to the students. So Professor Khaleil, yourself, and Francisco can also answer them because I'm aware that they've been with us since 5 o'clock. So I want to give them, you know, the opportunity. Okay, I cannot. First of all, I will have a word with my students because they have the freedom to ask whatever they want to ask now. I think Nathan answered most of the questions that was addressed to him. So we go to Francisco. There is like a very specific question that was directed to you by Massa. What role can the Palestinian court play in a state of emergency? That's very directed to you, Francisco. And I think there are 2 questions that is directed to you, Professor Asim, from Zaina. The 2 of them is from Zaina. And we have one from Rawan al-Irat. Do you think limiting the authority of the executive by declaring the state of emergency with the approval of the Constitutional Court, does it really consider an active tool, especially when constitutional courts are weak? We have many examples like the Egyptian Constitutional Court during the 70s, the Palestinian Constitutional Court currently, and many others in the MENA region. Can really like the Constitutional Court play a major role in ending the state of exception and being an independent one in its decision apart from the executive? This is also for you, Francisco. So I have 2 questions. Professor Khaleil, and I will continue. Please start with the answer. If you, yeah.
Me?
Yeah, Professor, would you like Francisco to start?
Yeah, sure. Okay. So with respect to the first question, that I guess is quite related also to the second one. So the role that the Constitutional Court of Palestine, you know, could place in times of emergency. I'll start by saying that the basic law, obviously, of Palestine does not explicitly grant the Constitutional Court the power to review the proclamation or the extension of a state of emergency. This is crystal clear. But I have to say that there is nothing explicitly that prevents the Constitutional Court from doing so. There are, you know, constitutional courts in the world that even if they were not explicitly granted by the Constitution, you know, the power to review the state of emergency, still they decided to intervene. So again, from a formal point of view, there is nothing that prevents the court from doing so. But second, even more importantly, in my opinion, the Constitutional Court of Palestine could really play a major role in times of emergency, because it has the potential, in my opinion, from a comparative point of view, to be one of the strongest constitutional courts in the Arab world, together with the Egyptian Constitutional Court. And I will explain you the reason in a second. There are very few constitutional courts in the Arab world that can be so easily accessed. There are a number of procedural gateways to the Constitutional Court that cannot be found in the vast majority of the other Arab countries. Palestine is the only country, the only Arab country, together with Kuwait, in which individuals have the possibility to directly petition the Constitutional Court. So you Palestinians have the possibility, to directly ask the Constitutional Court to review pieces of legislation and to ask the opinion on certain constitutional issues, okay? Naathán Brown, for example, was talking about the fact that sometimes what happens is that the emergency measures are translated into, the ordinary legislation. So my question is, are people in Palestine challenging the constitutionality of laws and regulations which are clearly in contrast with the Constitution, which are clearly in contrast with the fundamental rights and freedoms? Question mark. I think that you have the possibility, to do that. So also in a period of emergency, you have the possibility to directly have a dialogue with the Constitutional Court. And that's why this puts the Constitutional Court of Palestine in the position, to play a major role, for better and for worse. This depends obviously on, the decisions that the judges, will make. But certainly it has the potential to play a major role. The second question was, it referred, to the, generally speaking, to the role that constitutional courts can play during states of emergency. As I said before, obviously, constitutional courts are composed of people. So at the end of the day, it's their responsibility, to make a decision. What I can tell you is that obviously in some cases, such as, for example, in Egypt during the 70s, and even later, the Constitutional Court, first the Supreme Court and later the Constitutional Court, considered the proclamation of a state of emergency as an act of sovereignty. So this was a way to give wide discretion to the executive branch. But as I said, don't forget that more recently, in that very important case, judgment delivered by the State Council of 2013, for the first time, this idea of the proclamation of a state of emergency as an act of sovereignty has come to an end. So it shows that courts can also change, their opinions, so they can play an important role. And second, I also gave the example of Colombia, which is one of the most activist and boldest constitutional courts in the world. In Colombia, if nowadays there is not a state of emergency currently in place, as it was the case in the past, it is thanks, to the role played by the Constitutional Court, which invalidated a series of decrees proclaiming the state of emergency. For example, in one case, the court said the president does not have the power to proclaim the state of emergency because this issue, this problem can be faced through the use of ordinary measures. There is no need to proclaim such an emergency state, okay? I'm not saying that the role of the Constitutional Court is the solution to everything, but since thus far, up until now, the emergency rule, so the state of emergency, the state of exception has been the norm in the Arab world, I don't see a reason why not to try to follow a different path. Why not to try to follow a different strategy? Why not involving the Constitutional Court? I'm not guaranteeing the fact that it will stop this abuse of the emergency powers, but never say never. So it could be there is the potential for the court to play an important role, and at least to play certain limits, certain restrictions to this power. Thank you.
Thank you, Francisco. We move now to Professor Khaleil. Professor عاصم, you have many questions, actually, and we received so many questions on the email for you. Please, the floor is yours to answer.
I have to leave at 7. They're closing the university, they are telling me. So I really will be brief. And if you excuse me afterwards, I have to turn off my camera and get out of the university before I sleep in my office. So one is very fast, the disagreement, the one that was mentioning between academics on such matters and how can we deal with it. Actually, just to respond to that very briefly, I disagree with myself often. And if you listen to my presentation, I was disagreeing with the approach I have adopted in the past, and I will disagree in the future with the ones I tried. And this is a human fact, and I think this is part of the pluralism that Naathán Brown was talking about, and I appreciate any disagreement in that sense, even with you now disagreeing with my approach.
Never. Professor, you are my mentor as well, and you know that we respect your work very highly. And as you said, disagreements, and I don't know where this came from, but I will have a word with my students, because whenever we teach them, we always say this approach for this professor, and this is the approach for the other professor. Yeah. It's fine for disagreement. So exactly. Yeah.
The second one is that the image I try to say to respond to Massa. She said, well, the Constitutional Court play a role in, and also a question that was raised to Francesco. I believe, yes, within the framework of the theatrics, the theatrics of statecraft. That is, the state of Palestine is like a theater. We have roles, and the Supreme Constitutional Court, yes, they have a role within that theater. If we look at it from that perspective, I agree. They are assigned a role within that theater. They will play it, but they all contribute to the same theater and the same story, nothing more. The third example and image I try to say is that, and in that sense, I agree with Professor Saimon's suggestion that possibly Agamben would be very relevant still. And I'm not saying I'm excluding it, but I'm also saying that I'm aware of the critique. So this makes the approach even more interesting for me, is that the approach I adopt often is that about the role of our role as academics, role of constitutional institutions, etc., is within the prison-like setting. So yes, we have the prison has a leader, has a president, the prison has a court, the prison has laws, it has a constitution, but prison it is still. So that image also, I wouldn't mind continue discussing at long about the role of Constitutional Court in that prison, but the fact that this happens within a prison makes it completely different experience than a role of Constitutional Court in another setting. Third point, and then I'll stop afterwards, is that I didn't suggest, and I try not to suggest solution or answers. What I try to do is offer some kind of revisiting of the questions. And this is I believe it's very important to do personally, but also I invite others to do. In a sense, I'm not activist, and I'm not arguing for one set of solution to deal and how to get out of the status quo. The theoretical approach I suggested are not a recipe to get out of the status quo. It's a recipe, I believe, that could help us understand better the status quo. Now, how we can get out of the status quo, I suggested at the end of the presentation, is not the concern of the theory. It's your concern as students, your concern as activists, your concern as lawyers, and your concern as law professors. But in my interest right now into the theory, I'm actually trying to do a very simple thing. I'm trying to understand what's going on. Like, join me in trying to understand. Now, before we go to the activist role, I believe let's agree also on the framework, on the assumption, on the premises. Otherwise, we will be like in Babylon, talking different languages, no one, and that's what also I think Naathán Brown referred to at the conclusion, that the thing is not also we are leaderless or we have a problem with the leadership, is that we Palestinians too, we don't speak the same language, we are not actually building a common or narrative about what's going on. So that's my contribution. It's not the only one, it's not the most important one, but that's what I'm trying to do with my research. with this, I have to go. And
if you can just give me 1 second before you go. No, because this is super important. I know that there are so many questions that needs to be addressed and answered, but unfortunately we exceeded the time limit for our webinar, as usual. I would say I will refer the questions to the speakers, and we will try to get the answers and pass them to all the students attending and the other attendees. We have to emphasize that we have students from the West Bank and Gaza as well, and that's already like our greetings go to the people in Gaza who attended this webinar. Let me start by ending this. There is a question about the state of exception. We will discuss it later and how the paper was used. I don't want to go through that direction, how the paper was used for declaring the state of emergency, because as an academic, we are not responsible of how our work is being used as we put it there. We don't know how it's going to be used. I just have to stop with that. On behalf of النجاح University and the 5th webinar, I would start by thanking locally. I will go reverse now. I will start by thanking Professor عاصم خليل. Professor Khaleil, thank you for being also partner with us in the Constitution Awareness Campaign by giving voluntarily lectures to the students. You and the other colleagues of Birzeit University, our dear friends who participated also in the campaign, who believed in this idea. Thank you dearly. As I said, I wanted also the students to listen to you, as I had the privilege years ago to listen to your lecture, and it influenced me. Thank you so much for all the discussions. Thank you. I would go now to thank, also in reverse, Dr. Francisco Bياجي. Francisco, thank you deeply for being with us, for being very supportive of all the constitutional campaigns, for accepting to take part in this university webinar. It gives me a great pleasure whenever I read your work, your analysis on MENA region, constitutional, courts, constitutional design. I have to say your work has great value to myself, to my students, and also to other students that will read also the new paper that you wrote about constitutional courts in MENA region. Thank you dearly, my dear friend. Also, finally, I would like to thank, but not finally, I would like to thank deeply my mentor, my internal examiner, my dear friend, and my, I have to say, one of the great minds in political science in that early age, to be a professor, to be the chair, to be the director of Richardson Institute for Political Studies. Thank you so much, Saimonn, for always being supportive of the work we are doing at the Constitutional Center, and also to النجاح University and the partnership that is always growing between Lancaster and النجاح. I think there is always support and link, and on a personal also level, thank you for being very supportive to all your previous students. That's amazing, and I'm very happy that the students from the West Bank and Gaza had the chance to listen to your work that you have been doing for the last 6 years on Agamben. Thank you dearly. I would also thank our dear Professor Nathan Brown for being with us. Amazing scholar, we all influenced by his writings in Palestine and MENA region. And thank you again, Saimonn, for the introduction that you've made with the sectarianism and project. And I think it was very fruitful, and we always welcome to have Professor Nathan Brown. And I think students were extremely excited, as we are all, to have him with us. To listen to his ideas, and hopefully we'll have him in different platforms. I would like to thank Arsene for the extensive translation that he's done for the past 2 hours. I would like to thank my dear colleague, Dr. Munad Mehdi, for sitting the webinar and all the webinars that we've been doing for the university legal aspect, the legal webinars of the university. I would like to thank all the team that helped in putting this together. And most importantly, I would like to thank the students, all the universities involved, people from the West Bank, people from Gaza, all the lawyers also. At the Bar Association, we have around 30 attendees from the Bar Association, which is great to be interested in constitutional matters in Palestine. And also all the professors from other universities in Palestine that attended and participated. We thank you deeply, and we hope to have other webinars with longer periods, but our time is limited. Thank you again, my dear friends and colleagues and the dear students and attendees. باي باي. مع السلامة. شكرا كثير. باي باي.